210-4179. Mr. Jeff House is present. Mr. Brooks, Mr. Nick Crosswell from the state of Ohio. Good morning.
So, that's what here.
Yes. Yes, so the rain is tomorrow. All right, Ms. Howard, on Mr. Brooks, can we continue this? His arraignment is tomorrow. He will be in our courtroom for DSC and the new charge then. Usually 2 weeks. All right.
The last day for the 27th.
Yes. Yes, that's
Or the 27th.
well, we let's see, it's out. Can we do the 21st, Ms. Howard? 21st. Is that 2 weeks from tomorrow? Would that be a good time to put the rating on? Put the DSC on?
It's a vehicle, so far, it's on that
Or this is in that for,
21st.
Is that?
it works for me.
All right, so let's continue on first. All right, so we'll continue this matter in 12:21. What time is Howard?
9 a.m.
9 a.m. And this will be by Zoom, we wait time.
I wait time, that'll be both cases, Your Honor.
Yes, that'll be both cases, I'll put them on.
And so would you email me the Zoom?
We will, we do that today before. You don't have to worry. You wait his presence for the day.
I'll be here.
Okay, have a great day.
Thank you, Judge.
Uh-huh.
Could I have the minibus so that I could go see him when I get a chance? I've got to go to Shannon.
We do Stockton, Your Honor.
All right, excellent. All right, this matter of the State of Ohio, Bridge Stockton, case number B 210-2842B. This is the final pre-trial conference. Mr. Matthew Miller is present for the defendant, Mr. Nick Crosswell for the State of Ohio.
No, Your Honor.
Okay. We wait his presence.
I mean, yeah, I got news. I got news of his brothers in Craig County Jail. He doesn't think he necessarily will be held.
Oh, do they have a proposal in there?
Correct.
He's there on the charge. What he's serving. So is he serving a sentence there, or is he?
I think there's sentencing in January, but I think it's charges that were existing or cases called with probation violations.
All right, what I'll do today is I have no choice but to move on, so that when he's finished with the those, they can lodge it there and then we'll back here. Okay? Do you want to stand, please?
Actually, Your Honor. Here.
Okay, not, okay. All right, so I'll go on with Tom. For request to withdraw, Mr. Miller was granted the cause, and I will issue a capious $100,000 straight secured for Mr. Stockton. Who is in custody in Kentucky. No,
You don't touch on the ground.
we're cracking.
Thank you.
Thank you so much.
Can we get it in?
Sure.
Will we vacate the calendar, please?
Someone saw saw that, did you saw the one?
No.
No,
No, that's me.
Yeah, I'll get some white out. You need white out, anybody?
Yes.
Some tape or.
Some
more room working?
I know.
Regular
Well, we're not gonna finish it, we're not gonna build our desk.
Oh, you can get layers and stuff?
Oh,
wow. I know, it's just, I saw it this morning. It's so much bigger for everybody.
Yeah, this is really nice.
Thank you.
Yeah.
I made
The
it.
carpet's new. It's
Yeah.
very nice.
Mr. Crosswell, in that last trial that we had, remember the officers could barely sit in the seat?
I know, they're like this.
Yeah, and I told myself, just take the whole thing out, we can't have people comfortable.
That is wild. You know, this is the room I was standing in on September 11th, 2001.
Are you
Probably
kidding?
Jill, who passed away from shit at brain injury. And I just, the whole thing now kind of reminds me of, you know, when Judge Crush was here too, and it was all,
Yeah,
it was that old,
yeah.
yeah, so every witness I ever had a problem getting into that.
All of
Every one of them.
Yeah.
They would always fall.
It's kind of the officers, you know.
Oh, yeah.
So we just have to take it out.
They had a really big trial. Kyle Anderson had it, and they had a bunch of people. It was the LA Sound Center. They had set a witness on fire on the, it was the Morel family in West End, and they had, anyway, the guy survived, and they killed him at the LA Sound Center. I still remember that trial. They had all these people up here, and it was just really wild, you know. Probably pre-coded. Anyway, I just remember that trial because everybody had, they were warning everybody, you know, people were running and stuff. Yeah, that's tough. And judgment. Well, I'm gonna go and come back. I'm gonna try to find Mark.
Who are you waiting on?
Mr. Tierney, but he had a couple rooms. I'm trying to find him and get him back. We Thank you.
It makes people look at it, still be natural, they don't know. You know,
Yes, we probably need to move it a little bit because Mr. Crosswell is going to stand right now. So I moved it over a little bit this time. Okay.
on TV.
Yeah, it's live, live streaming.
Right now it is?
Uh-huh.
No.
Yes.
If you turn the TV off, you get tricky, you yeah, tell me when you're doing this, and then legally you're, yeah. Oh, yeah, that's right here.
You were live streaming on Monday too.
Oh, you watching?
So I'm gonna call Brad.
For transparency, public transparency.
Like every day now? Or?
No. And we have, this is the second day we've done this trial now. Mr. Keller, are you ready?
Yes.
All right. Yes. All right, this is the matter of State of Ohio versus Gregory Smith, case number B2103404. Mr. Smith is present in court with his attorney, Mr. Keller. Mr. Croswell is present with the State of Ohio. This matter was set today for a plea, and it's my understanding that the parties have reached an agreement. Is that accurate, Mr. Keller, Mr. Croswell?
Yes, Your Honor, we're going to be pleading guilty to the fentanyl and not guilty to the cocaine, or excuse me, change the dismissal to the cocaine.
That's correct, Your Honor.
All right. Is that your understanding today, Mr. Smith?
Yes, ma'am.
All right. Sir, are you the Gregory Smith named in this indictment?
Yes.
How old are you?
I'm 40 years old.
How far do you go to school, Mr.
I
Going to
got a
school?
GED.
All right.
I actually went to Cincinnati Jasper also.
Okay, thank you. So you're able to read and write English language well?
Yeah,
Um,
I am blind in my right eye, but
All right. Have you ever served in the military?
no,
Are you a U.S. citizen?
yes,
Sir, I have in my hand two forms, one entitled Waiver of Trial by Jury. It's a single-page document, and then the other is an entry withdrawing plea of not guilty, entering the plea of guilty. It's a 3-page document. Regarding the waiver of trial by jury, there are signatures at the bottom, and I recognize your attorney's signature here. Is this your signature here, sir, where it says defendant?
yes,
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand I have that right, but I am waiving or giving that right up. Is that your understanding of what you were doing when you signed this form?
yes, ma'am,
Did you sign this form after consulting with your lawyer, Mr. Keller, about your constitutional right?
yes,
Do you have any questions about this form?
no, ma'am,
Do you have any questions about your constitutional right to a trial?
no,
All right. Sir, I also have in my hand this entry withdrawing a plea of not guilty and entering a plea of guilty. It's a 3-page document. On the 3rd page, there are signatures. I recognize the prosecutor's signature here in his bar number, and then your attorney's signature here. Is this your signature here where it says signature of defendant?
yes, ma'am.
All right, thank you. Mr. Crosswell, please put on the record the party's intention here.
The agreement, Your Honor, is to be pleading guilty to count 1, plead of distance, and knowledge count 2.
All right. Mr. Smith, are you under the influence of any drugs, alcohol, or medications today?
No.
Do you now, have you ever suffered with or even been diagnosed with any type of mental health illness or difficulty?
No, ma'am,
Are you presently under any type of probation or community control supervision in this or any other state?
no, ma'am,
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
no, ma'am,
Has anyone promised you anything at all if you enter into this plea of guilty today other than the dismissal of count 2?
no, ma'am,
Are you making this plea of your own free will?
yes, ma'am,
All right. Sir, the prosecutor and your attorney have indicated that it is your intention to plead guilty to count 1 of the indictment, a felony of the 5th degree, which is possession of a fentanyl-related compound in exchange for the dismissal of count 2. Is that your understanding?
yes.
Is that what you talked with Mr. Keller about before this hearing today?
That's what he explained to me, yes,
Have you had an opportunity to read this 3-page plea form
yes,
and review it with your lawyer?
yes,
Do you understand what it says?
yes,
Do you have any questions about it?
no, ma'am,
Mr. Smith, have you had enough time to consult with your lawyer about your case before today's proceeding?
yes, ma'am,
Has your lawyer answered all of your questions to your satisfaction?
yes, ma'am,
Have you had an opportunity to review or discuss the evidence the state has against you with your lawyer, Mr. Keller?
yes, ma'am,
Mr. Croswell, would you mind putting on the record whether the state has provided all discovery, including any Brady material, if any, to the defense to your knowledge?
We have, Your Honor.
All right, Mr. Keller, you acknowledge you see the same?
I do.
Mr. Smith, are you satisfied with your attorney, Mr. Keller?
yes, ma'am,
Now, sir, do you understand the charge against you, possession of a fentanyl-related compound, a felony of the 5th degree?
yes,
You understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in count 1 of the indictment.
yes, ma'am,
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
yes, ma'am,
Now, Mr. Smith, this being a felony of the 5th degree, do you understand that you are facing up to 12 months in prison and up to a maximum fine of $2,500?
yes, ma'am,
You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years. You understand?
yes,
Now, the form says 3 years, but Mr. Keller, I just want to remind you that the post-release control times had changed as of September 30th.
I just did it to comply with the form, so it's 2 years of time.
Okay, so can you just change that to 2 instead of 3? All right, you get my initial. So the post-police control time could be up to 2 years instead of up to 3 years. Do you understand that, Mr. Smith?
Yes, ma'am.
All right. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes, ma'am.
Are you on post-release control?
What's that?
Are you on post-release control?
No.
All right. Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am. I haven't been in trouble in none of my life.
All right, thank you. Since this is a felony of the 5th degree, Mr. Smith, community control is a possibility. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison?
What's that?
Community control is correct.
Probation?
Yes, ma'am.
All right. Do you understand that if you are placed on community control sentence or probation sentence, you will have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control or probation and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include anything up to imprisonment of up to 12 months. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay the court costs, I could order you to complete community service instead of paying court costs. Do you understand?
Yes, ma'am.
All right. Any questions so far, Mr. Smith?
No, ma'am.
Sir, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a right to have a trial either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes, ma'am.
Do you understand that at trial, the state of Ohio has the obligation to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
Do you understand that at trial you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I've explained them?
Yes.
Do you have any questions about your constitutional rights?
No, ma'am.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
Yes.
All right, sir, knowing everything the court has told you and discussed with you, do you have any questions at this time?
No, ma'am.
Do you still wish to enter a guilty plea to count 1, possession of a fentanyl-related compound, felony in the 5th degree?
Yes, ma'am.
All right. Is there anything further from counsel before I accept the plea?
Nothing else, ma'am.
Can you hear the statement of facts?
July 1st, 2021, Hampton County, Ohio, defendant knowingly possessed fentanyl, Schedule 2 controlled substance. At the time of a traffic stop, during the course of the stop, there was a canine hit on the vehicle. The drugs were located in the car. Defendant said they were missing.
All right. Mr. Smith, did you hear what the prosecutor said you did?
Yes.
Is it true?
Yes, ma'am.
All right. What is your plea to count 1, possession of a fentanyl-related compound, a felony of the 5th degree?
Guilty.
Let the record reflect that Gregory Smith was present in court with his attorney, Mr. Keller, and that Mr. Smith is informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Gregory Smith understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Gregory Smith guilty as to count 1, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of Revised Code 2925.11, subsection A. Count 2 will be dismissed at the state's request. Is there any reason why sentence should not be entered today?
We leave it up to the court's discretion whether to do a pre-sentence report. We're prepared to go forward with sentencing, that's the first question.
All right. Well, I know nothing about Mr. Smith, and, I know there's a presumption of community control. So at this point, I wouldn't have any reason not to do that, but I would like to know a little something about him.
Understood.
And you can either do that by way of a PSI or a sentencing note.
What's happening now?
A pre-sentence investigation where the probation department does a investigation. That takes 30 days, Mr. Keller. A sentencing memorandum can be filed and we can do a sentencing next week.
Can I come one?
Sure.
Yeah.
Your Honor, after speaking with my client, he would prefer to proceed with the sentencing memorandum.
All right, let's get a date. I will not order a PSI.
And I did want to thank you for that lady that you introduced me to, Miss Denise. Thank you.
Yes,
Thank
so you connected with the health community.
Yeah, she
access worker?
recently got a hold of me today.
Excellent, excellent. I'm happy to know that. The 20th. Nothing? No? Okay.
20th would be good.
All right, we're waiting for PSI and set sentencing for Monday, December 20th, 9:30. All right, so Mr. Smith, we'll see you back here on December 20th at 9:30. And counsel, I'll ask that you file a sentencing memorandum by next Friday.
By the,
Next Friday.
next Friday.
Yes,
Will
sir.
do, thank you.
Thank you very much. Have a good day.
Thank you.
Thank you, ma'am.
All right, thank you.
We approach on Rohan, Your Honor.
Yes.
Oh, we had it on before, Your Honor, the wrong thing with campus.
Oh, that's right. That's right. Yes. Let's put this in the trial date sometime April, Mr. Rohan, and then a clear trial setting, and then 30 days or you do that. Okay. So.
In the trial setting, you do, January the 5th.
It's a Wednesday. This Wednesday.
I can't be here because of what we did for me, but I can be here the first.
Well, is it good for around 9:30?
Yeah, I can be here.
Which time?
Everything, 9:30.
9:30, right, 9:30 this hour. For the clear trial setting, and we set a trial date sometime in April. Maybe April.
Schedule the trials like you do, is everyone's schedule always available 5 months down the road. There's another problem. There's more for me, there's more for me.
You understand my method there, Mr. Yeah.
We could do, April 25th.
April 25th. All right, April 25th it is, thank you.
Yeah.
Which time?
We
We had,
Yeah, he's on.
That's how you shut the trip. Okay.
Last week, she got an office said they were supposed to be.
hey, 5 years. Yep, everyone's on board with that, so. Put down you. So the public of the victims. One guy click.
Like, there needs a bike, yes,
But it's on that. And then one guy sent me another release finally, so I sent that off to receive, so. Should be coming. Next release. Yeah.
Who else?
I mean, we're getting there. August, we're getting there. I mean, it takes about the right time for the bike to roll in, 4 months. As sad as that is, but, I mean, so I've made a couple requests, so I have that. Yeah, fine line. I gotta keep the anticipation, but when it comes in with silver leaf, you'd be like, oh, oh, you're not? You got that.
Yeah.
Thank you, Dave. We approach a Morales, Your Honor.
Yes.
We are still waiting on 5.
Okay. You said so.
Where's Morales?
Oh, that's. All right, see here. He's all that. All right, we'll bring him down because I want to do All right, we're going to start on today. You want me down? No, I was just gonna put it on. All right, so, we can, okay, when is, requested?
Been a while, Your Honor.
It was about 3 months.
82. Or 4.
Okay. You want a second request?
Yeah, I've already done it.
Oh,
I did whatever the court hearing after once. So I'm gonna look at it.
Oh, gosh. Okay. All right, you guys, questions? Yes. Okay. Let's do this, previous.
Yeah, I made a second request after the last hearing.
Okay.
Call for against.
You have time. Okay.
Is it okay to do it on Zoom then?
Yes, so we're going to see today the next hearing.
Oh, that's every time.
All right, so we're good. 21st is not 3 weeks. And 2 weeks. That's fine. Yeah, I will do it sooner than later, as snacks. So let's do 12:21.
Yes, we have, so that's 21.
Diane?
And that'll be on Zoom?
Yes, ma'am. We'll send you the link to the date.
Okay.
All right, and you will bring that in.
Okay. Yes. I'm gonna probably stop in another recorder and check it first and then.
Okay.
No record, writing communication for the boss man. We read.
All right, council, you ready to talk about the case?
Yeah, Robinson, Your Honor.
All right.
Just want to get in with my body camera.
Okay.
August request, 80, 11, over 4 months in.
Tell me myself, all right, is he here? She is. All right, so you made her presence today. Okay. Okay, no worries. Can we continue Robinson 30 days, discover still outstanding? I can. Look to that.
They're asking for them one.
January 5th, 9. You all right, Ted? All right, January 5th, 9 a.m. Speed trial. Thank you.
You get discovery from,
No, I don't feel it.
all your senders need to be electronic stuff.
I got paper.
You're making a joke and else. You want to look at it, you can turn around.
Okay.
Like a silver ball or something.
I'm doing great, you?
I'm doing pretty well, thank you.
Yes.
I did, yeah.
So you get
It's
your.
on
Mr. Croswell, you have one pretty high.
Yes, Your Honor.
Okay.
Yeah, I think it said Mr. Perkins, the, Evans.com stuff on this.
Okay, so you do have that.
Yeah.
Yeah, the paper stuff, and this is his first appearance on this.
Appreciate it. Yeah, I did have, I could have like 30 days to move all that, and then you can address this problem.
All right, so you're asking me to continue this 30 days, but usually someone's locked up, I continue 3 weeks, I will do it if you request 30 days.
Okay.
And you want to bring them down to address the problem?
If the court will allow that.
Okay. Ms. Howard, can you, call down Mr. McCree? Now, I really read this, I appreciate your motion for the bond. I will tell you,
Right, and only,
and I actually want.
I understand, I understand.
He was on the box.
No, these do not show.
He was 1,010 on the previous one, so he's not around.
All right. All right, well, he's just gonna down,
Take
okay?
care. Yeah, I appreciate it.
So we're gonna do the first days on, three, 30 days, 30.
We can do, January sixth.
So it's January sixth?
Yes.
That's good.
Okay.
January sixth at 9:30.
Okay, great, thank you.
January 6, 9, 30, all right, we'll do it fine right now.
We'll look into this.
Let's see if someone to live.
He does. I spoke with his mother and his grandma, so they both on that place.
Well, I think it's the travel too. Mine's not.
So we can do this too.
But yeah, he's got probably 2 or 3 more. Listen, I'll check.
Mr. Perkins?
Yes,
You get this, so you can talk to your client about it. Yes, this- Well,
Yeah, that's not.
it's not-
Okay, great, thank you.
You do need to send a copy off. So,
Well,
it's
I
gonna have to
haven't.
It's, 200 bad years.
Yeah, it's that's
Yeah, it's just-
Yeah, there's, so, are we gonna be looking for you?
Mr.
I'll check with
Perkins, are you gonna want to set this for January?
We just said it for a jury.
Okay. Yeah.
Sir. Come on.
All right, so he's on his way down.
Thank you.
You have anything ready we can discuss while I wait for Mr.
I'm working on it, Your Honor.
Okay.
Trying to get everything I don't have anything yet. Should be coming.
Yeah. So what'll be a couple more months.
You guys coming down, let's get a date. Can we get a date on story, Your Honor? Like a
Yes.
story.
Uh-huh.
We are waiting on body camera for CTV.
Oh,
It was only 2 months old, a little over 2 months old. but
okay,
Still in the,
yeah.
Mr. Story is locked up. There is a $5,000 downstairs Judge Greenberg, which he would not be involved in. This, Story is not going to be able to make even that 5,000. So until I get something moved down there, it's really probably not much to address here.
All right, thank you, sir. Well, you ready to presents then for today?
Yes, I do waive his presence. Actually, he was not cooperating with the people in the jail, so I was upstairs and they had not even tried. We're not able to even bring him over. They said it just didn't respond.
I see. All right, let's continue in 3 weeks or, are you all right to go out, in some holidays, 30 days?
Yes.
All right.
We can do, January
January 5th?
Could we move that back a little bit? I believe I have, him down and Judge, well, him down and Judge Greenberg's room on this, so I guess we could do that. I could go down there, see if I can change anything down there and then come up here.
Okay.
Okay, so.
So, like,
yes,
want to
we'll
do
go
like
with it.
9:30 then? 9:30 on the 5th?
Yes, that's one.
9:30 on the 5th, January 5th, 2022, 9:30, you waive the speed trial?
Yes.
All right, thank you.
Thank you.
And, you allow us, I will do, the electronic signature?
Yes.
Thank you. So we'll have 9:30, time to go down to that case. All right, thank you.
So you have the hallway, it's a million square feet.
It's for 94.
See that?
Can we approach on Janetti, Your Honor?
Yes, sir.
Discuss maybe last time was
Well, yes.
So, yeah, I think so. He was in charge of section 94. No, I disqualified. There's no did disqualify. This is in Texas, so, can we get a little more data? At least. There's a change order. Said, the state.
All right,
He's at no travel.
all right. Well, let's get it done. Okay, so I'll see you, back to the actual report.
Okay.
Is that what Okay.
And I'm going to bring something out to
Yeah, so, Janelle, ask for a report for policy intervention. We'll make the referral. And let's continue this out about 30, 35 days, to give you time to do it. So let's.
Yeah, talk to, Travis Baker.
Wait, time.
Yes.
January 13th? All right. So January 13th, 2022, 9 a.m. And we'll get the referral. Is there anything he signs our clients here, this client's here? For the referral. All right, easy. Okay.
What date do you pay on?
I have that. We have, January 6th. Council, will you file this? I will see.
What's that?
You have to have her telephone number, make sure that information is accurate. You always need to make sure that information is accurate.
On the,
address.
or, yeah.
Council, the motion for ISC is to be filed on Friday.
Okay. Cool. I'll make that.
You need that.
Okay, get done today.
It's Friday, 10.
We approach on Kelly, Your Honor, Mark Kelly.
Yes.
Mr. Keller has him.
Kelly does the whole meeting.
All right.
agenda is set for January 13th. She has to do the same date. Okay, probably.
All right, then, Ms. Howard, can we set Mark Kelly, same as co-defendant, Genetti, which is, January 13th. January 13th at 9 a.m. Please keep track.
We do.
All right, and, you have some discovery?
We received informal discovery, I have formal discovery, but I'm not gonna ask a question for you, give me that, unless I'm gonna practice it. I have the questions, so.
All right. All right. Okay, thank you.
Thank you.
Going on.
Give me part of that, I give you the deal. I'm like a couple years off. I'm actually live streaming.
This is where it's going. And correct me, please correct me if I'm wrong on this. Okay. There's one factor to us that needs to be really different. So this is.
But she said she checks it out. All good? You can.
Ultimately, one thing.
Right, so there's 100%, so I'll vote Mr. Further, counts 3, 4, 5, 6, 7, 8, 10, 11, 3, 6, 7, 8, 10. So essentially,
Mr. Keller, you better go back and on your client, Mr. Keller, you wait time.
Oh, we do.
Just toss it.
This is a matter of state of Ohio versus Yolanda McCree. Case number B2101409. Mr. McCree is present in the courtroom with his attorney, Mr. Brian Perkins, Mr. Nick Crosswell of the state of Ohio. This matter is set for a clear trial setting. Before Mr. McCree was brought down, I had a pre-conference with the attorney. This is my understanding. Discovery is still outstanding, Mr. Perkins?
Yes, Your Honor, there was a prior counsel, and I believe they've already received the evidence.com, but the prosecutor's going to resend that to me so that I have the electronic discovery.
All right, excellent. So are you asking for the court to continue this matter then?
I am, yes, at my request, Your Honor.
All right, so we will continue this matter to January 6, 2022 at 9:30 a.m. But we do have a pending motion to reduce the bond. I have reviewed it. What would you like to say in addition, Mr. Perkins?
Your Honor, we'd have support if it would consider reducing the bond in this case. My client, his current bond is set at $50,000 straight, which he does not have the financial means to make that bond. He understands that he failed to appear on a scheduled court date, and he is apologetic for that. He indicates that he was sick at the time, and while that's not an excuse, he is sorry that he did not make it. and he has indicated he would certainly make all future court dates. I did speak with both his mother that lives on Laura Linda Drive, as well as his grandparents Cynthia and Richard Burke, who live on Balboa. Both of those indicated that he is more than welcome to stay at their residence, and they would like him to stay there. So if the court deemed that acceptable, and certainly he could also be on electronic monitoring at those locations if the court felt that that was necessary. He does have 2 children, ages 1 and 2. He does have, indicates that he has employment available. And again, his family members are willing to allow him to live there and make sure that he does make it to all his courts. This is while it is, obviously it's a felony of the 4th degree. I don't believe that in this case, pretrial incarceration is necessary to protect society or to assure his presence. I think the court could implement other means, such as electronic monitoring, to ensure the court that he is doing what he's supposed to be doing.
All right, thank you very much. Mr. Croswell?
Your Honor, I believe you set this bond at $50,000 straight to clear, failed to approve the court. He was also met habeas for at least, the habeas was issued end of September. So over about 2 months, Your Honor, he was sitting there to himself at any point. As that bond remained the same.
All right, Mr. Dupree, how old are you?
I think my current 21 November the 8th. November the 9th.
All right, 21. What have you learned? You've been in the Justice Center since about 15. What have you, since November 15, almost a month?
I came in November the 8th. On my
Okay, so actually, a month. What did you learn about not coming to court?
Not the right thing to do. I really,
What did you learn about notifying the court if you're sick and you can't make it, or notifying your lawyer?
yeah, one.
So, I asked that we learn because I don't want you to do it again.
I want
I want you to understand the seriousness of not staying in contact with your lawyer, not coming to court when you're supposed to. You understand the seriousness now? All right. I'll grant a motion to reduce the bond to reinstate the original bond that was set, which I believe is 1,010%.
That's correct, Your Honor.
I'm gonna go ahead and reinstate that. Now you know, come to court. Then come to your lawyer, all right? So, January 6th, 2022 is your next court date, all right? Stay in at 9:30, stay in contact with your attorney. Let's set the trial date too, because this case is starting date. March 14th, huh? March 14th, March 14th.
That'd be fine, Your Honor.
All right, March 14th, 2022, 10 a.m. All right, so the original bond is going to be reinstated, so there's nothing to post. You understand? You'll get out, go home, be with your family, don't get you in trouble, and make sure you stay in contact with your lawyer. All right, and do you have a waiver form?
Yes, Your Honor, I have, that has been signed, so I could approach.
All right, thank you very much. So let the record reflect that I need to hand it the defendant's waiver of speedy trial. Is this your signature, Mr. Dupree? All right, you signed this today? And then you go with your lawyer? All right, thank you very much. We'll see you January 6th.
Thank you, Your Honor.
Thank you.
You want to agree to it?
All right, I have 3 lawyers in the room. Is there anything I can talk about?
Yes, sir.
We're all over the top.
Perhaps we do it too much.
It also a little more expensive than.
I like the carpet.
Me too.
Very nice. Beats the stuff upstairs, that yellow paisley mesh.
It goes well with the marble.
Thank you. And then we got this new.
Oh, that's new? What did you get over, right?
It was half wood, half brass. And then we built it.
Funny how you get used to things and you notice that there, yeah.
We wanted to, we did is we took out the wood stand. There was a tiny wood stand, and over lost. Makes it bigger for the more comfortable for officers.
Yeah.
People who are, larger snack. All right, what case do you want to talk about?
Judge, I have Jay Barnhart, it's a clear trial, so he's out of ball. We already picked the problem.
Okay, Mr. Crosswell?
Yes,
Mr. Harrison is up here talking about.
he's going behind my back.
No, right in front of your face, man.
Right, you distracted, you see out there. Start the picture.
So Mr. Hunter's here, that's all we got, we got that one. All right, go ahead.
There we go, we said for trial, my suggestion is we combine more cases or something. So we don't really limit this at trial.
All right. So we'll need to click on, the case ending in 1538 on for trial. So it's not set for trial. And we'll put that on for trial the same day as the
That was
other.
not, I thought we said it in March, on 10/14.
Yeah, on 10/14, we set the A number for trial. We're gonna set the other one, but we're gonna do it now.
You sure that's the date? I don't have it.
3/21/22, yeah. 10 a.m. All right, so, so both we set, and then do you want a date in between now and March?
I'll check with Mr. Cross, I'll see what we can check out.
Well, I would set a final pretrial conference on lower that, way, you know, it's going
Oh.
This is how we can have a pretrial conference on both numbers. The trial date is, 3/21, so either late February or
What's the 7th of March?
7th of March.
It work?
7th of March or late February.
7th of March?
All right, March 7th on both for final pretrial conference. March 7th. What time, 9 a.m.? 9 a.m. Mr. Aaronstein, because your client is here and we're setting these, I'd like to at least get his acknowledgement of consent to waive time, so. you can bring it
I'll
up.
be done.
Thank you. Mr. Aaronstein, you can, yeah, bring one in, that's great.
I should do it now.
All right, this is a matter of state of Ohio versus Gary Monitor, case number B 210-4120A and B 210-1538. Mr. Russell, would you mind handing these to Mr. Ernestine? All right, Mr. Hunter is present, and Mr. Hunter, before you walked in the courtroom, your attorney and the prosecutor and I had a brief conference about your case. Your attorney, once more time, to talk to you about your case and you can decide what you want to do. But you put both cases together and they'll both be on trial, set for trial March 21st, 2022. Understand? And then we set a final pre-trial conference on March 7th, 2022, just to make sure things are on track and it's actually going to go to trial if it goes to trial. And so at this time, I'm just going to ask, your attorney says that you will waive time, your speedy trial rights, and so I gave him 2 forms, and I'll ask him to review that with you. All right, I been handed the waiver of defendant's speedy trial. Mr. Hunter, are these your signatures here in both these forms? All right, you signed these after consulting your lawyer. All right, thank you very much. We'll see you all back March 7th.
Thank you, Judge.
Thank you.
Yeah.
Thanks, Jones.
Morning, Judge, how are you?
Good, how are you?
Yeah, not bad.
All right, you ready, council?
You want to bring our clients in here on or in the hallway?
Oh, they are here?
They are.
Okay.
You said a couple of times ago to bring them here.
Yeah, why don't we put it in bring them on since they came on down.
We going separate? Okay.
All right, these are the matters of State of Ohio versus, Mr. Val Turner, case number, is that right?
Yes. Yes, this is.
B 2104782 and B 2100437B. Mr. Turner is present with Mr. Kevin Bobo. And this is also a companion case, State of Ohio versus Joseph McCluster, B 2100437A. He is present with his attorney, Mr. Richard Guyan, and Mr. Nick Croswell of the State of Ohio. These matters are set for a clear trial setting today. Counsel, how do you want to proceed?
Your Honor, on behalf of Mr. McCluster, as we left court the last time on November 17th, Mr. Croswell and I were discussing trying to resolve Mr. McCluster's situation. It's my understanding Mr. Croswell approached Rick Gibson with the prosecutor's office and they've made us an offer which we have rejected. It was shockingly high in our opinion as to what we thought was going to resolve. As such, we'd be looking for a trial date. However, Mr. McCluster was obviously out on bond. We would be contingent upon how Mr. Bobo wants to proceed. As you know, this case is a companion case to Mr. Bobo's situation. He and Mr. Croswell are still engaged in plea negotiations, but that's my plan, so Mr. McCluster, with your court's pleasure.
Thank you very much. Mr. Bobo?
Yes, Your Honor, thank you. Similar situation as Mr. Guyan. I have further spoken with Mr. Croswell about trying to find a reasonable resolution of this matter short of trial. He tells me that considering what has been presented to him, that he will see and speak to the powers that be in the Hamilton County Prosecutor's Office to see if reason prevails and we can resolve this short of trial. I know that this case is old. There's many, some F2s are really easy and some are much more complicated. This is a little complicated situation, and I know it's old. I don't want to make an assumption, but if the court wishes to pick a trial date, Mr. Turner would be willing to waive all time for speedy trial purposes. And I know that sometimes this court does a pre-trial and a trial. I can let the court know that our case itself will not be a trial because of statements that have been made. But if the court would consider doing a motion to suppress hearing trial as opposed to a pre-trial trial, then I think we're all set. And then I'm just waiting for Mr. Croswell to get back to me to see if reason prevails.
All right. Are we, I definitely don't want to get involved in any kind of plea negotiations, but does these cases involve mandatory time from your case?
On the drug case, it would try, yes.
All right. And that's where the sticking point is?
No, Your Honor. Mr. Turner has no prior penitentiary numbers. He essentially, the possession and trafficking is not something to be consecutive because it's prep for sale. There's 4 substances in one, so 1 F2 is really what he's facing as opposed to 6 or 7. So Mr. Turner basically has 1 F2, 1 F5, and then an F3 on the remaining case. And with no prior penitentiaries, the offer is twice the minimum mandatory sentence. So that's the issue that we're having.
I see. All right. Well, let's go ahead and get a trial date for both. Let me ask first of all to, I know that both defendants have waived time up to this point.
Yes, Your Honor.
Do they continue to waive time?
Yes, Your Honor. Yes, Your Honor.
All right. And I'm gonna ask that, since your clients are here, that they waive time, not only on the record, but that they sign the written waivers.
Yes, ma'am.
Mr. Bobo, here are yours, and Mr. Ryan, here are yours.
Thank you.
So let's set, both these cases, trial date and a final two-trial conference date. Do you, now, Mr. Bobo,
Yes, ma'am.
I'm just trying to make sure I understand what you asked for. Are you asking for motion to suppress that is pending in your matter be set, on the day of the trial?
I'm not, I know the court sometimes does final pretrial and trials. I was just hoping that we could do the final pretrial as maybe a motion to suppress hearing, just because we're not gonna have a trial. If, I know the court wants to get a trial date for finality, and I understand that, but, you know, our issue, keep in mind that, on my one case with Mr. Turner, which is the second case, but it's from May. It's not recent, the state of Ohio, it's from May, they waited months and months to file it. We're still waiting on DNA on that case, so I'm getting a trial date without having all the facts. On his original case, I'm told that formal discovery was sent out on December the 2nd, but I have yet to receive it, so I haven't went through all of it. But my belief is, with reasonable degree of legal certainty, that this will not be a trial. If we can't resolve it, the only thing we would have is maybe a motion to suppress on the first case, and I don't know in the second case yet because we're still waiting for DNA and stuff.
All right, well, let's go ahead and set the motion to suppress on 21-00437E first. Let's set a hearing.
And if, just so the court is aware, I mean, we are willing to wait time, and we are willing to get the last court date the court is willing to allow us.
I understand.
Thank you.
In January.
Thank you.
January 26th.
That's fine with us, right? That's fine, Ms. Howard, thank you.
That's for motion.
Yes.
All right, January 26th, 2022 at 10 a.m. will be the motion to suppress. Now, let's set trial dates for both defendants on all cases. Have you had an opportunity to talk to your clients about the waivers?
We did this
All
one.
right, you've already executed them? All right,
Yes,
may I see them, please?
Is the motion just on Mr. Turner, or is it also on Mr. McClellan?
I had it just on Mr. Turner.
Okay.
All right, so Mr. Turner, you have two cases, and I saw you execute these waivers of speedy trial. Let me ask you, are these your signatures here, sir?
Yes, Your Honor.
Did you sign these after consulting with your lawyer about it?
Yes, Your Honor.
All right, I'm gonna go ahead and enter the date as today on them, 12/8/2021. And then, Mr. McCluster, is this your signature here, sir?
Yes, ma'am.
Did you sign this after consulting with your lawyer?
Yes, ma'am.
All right, and we already have your date. All right, thank you, gentlemen. Let's go ahead and get trial dates sometime in the first quarter, maybe the end of the first quarter.
Thank you.
What do you want to send the other check, the marijuana one? Pre-trial? Or you guys did trial? See what comes in? Okay, gotcha.
Yes. I'll lay that. March 14th. March 14th.
Yes, Your Honor.
Set all matters set for March 14th.
Judge, I do have a murder case scheduled that day, my client is currently locked up, I can double book, as you know, some things hasn't happened.
Yeah,
That's set from the judge is, it is the second trial setting on the murder case.
okay.
I could do the week before, for March 7th, if anyone's available.
What is that? Action order 14? Yes. Okay, the trials. The trials.
How about the 20, 1st of March, would that work for everybody? Although I'm nervous, it's gonna take longer than a week,
Yeah,
sorry.
I think let's just go to 7/14. I know it's double voting at this point. And we're gonna plan a pre-trial conference, so if it goes, if you know, the pre-trial conference is gonna go, your murder is gonna go, then we can move this.
Good, thank you.
All right, so, 14th March, 10 a.m., and let's do, 2 weeks before our final pre-trial conference.
We can do, 28th.
Of February,
February 28th.
February 28th, 9 a.m. Are you all right with that?
Yes, ma'am.
Pre-trial conference? All right, excellent. February 28th, 2022, 9 a.m. Waivers have been, will be filed today for this to be tried. All right, even though this case is very old, I do want to, commend the defendants for, not getting charges, or having issues. I ask you to continue to do so. We will see you back here we'll see February 28th, we'll be back, for Mr. McCluster, and then on the motion to suppress for Mr. Turner, we'll be back January 26th. All right, thank you very much.
Too many numbers for
Good morning, Your Honor.
Good morning.
Apology to the court, Judge. Judge Bouchard didn't take offense to 9:30 in court today. Sorry. And Laura saying just ignore my text. Yes. I'm not at the top of her list anymore.
Can we approach on Frazier, Your Honor?
Yes, sir. Yes.
So yes, still sending free trial, and 2 MDLs on the second day.
Last time you received this stuff. You did not receive
It's all seen through.
Everybody read the bids? Ms. Howard Frazier, continue 30 days to your trial setting, please.
January 6th. January 5th.
January 5th?
Yes, sir.
Like I said, the week after, and that works better for me. I don't motion to press set that one in the state. I can jump in here before, but I don't know.
Can you go over, please?
January 13th.
January 13th. 9 a.m. What time?
Thank you, Your Honor.
Yes.
Yeah.
Anyway, Coach Young,
Yes.
Ralph Pryor. Yeah, my father. This case, Judge, she over the boundary. I actually set this for one war next week. His expectations, I believe, are realistic, but you can't know what it lasts. I like them, in that area, if the court can give me an opportunity to speak with you about that one more time.
All right.
I just assume.
All right, let's go over that. Mr. Pryor, let's continue it another 3 weeks.
John, for those days, I'm trying to vacate those trials.
I understand. Let's go ahead and set it for 3 weeks. Wait, speed trial.
Yes, Your Honor.
2 weeks or 4 weeks? 2 weeks or 4 weeks?
4 weeks is fine.
January 4th.
I'm here.
January 4th at 9.
I saw a federal, that's a 2 a.m.
Okay, it's 9 a.m.
Wait. I'm trying to get it.
9 a.m. clear trial site. All
Thank
right,
you,
thank
Judge.
you very much.
Sorry, Mr. Howard, I'm so late. I even got on Zoom thinking it was Zoom.
You were like,
We started at 9:30. I run up here, Don was like, dude, Luger's like, I can't run to 3:30. Well, you're up. Her sister, then she goes off the bed, she takes a phone call. I said, Larcy's gonna get me. Bye, guys.
all right, have a good day.
Thanks, man.
All right, Ms. Sully, all right, Ms. Sully and Mr. Wendy, if we're done. Okay. So, looks like Mr. Crosswell, you're just waiting on Ms. Sully.
Yeah, I don't have Mr. Winky still.
Yep.
The symbol's not on the record.
It's not forgotten. The civil matters, practice, is taken off, correct? Yeah. And Mr. Croswell, I think tomorrow is a Zoom.
I don't have anything to tomorrow. I didn't see anything at least. I thought you had a civil day tomorrow.
Okay, let me look.
I don't have any files for tomorrow.
I don't know why I didn't realize when it was a Zoom. We have one campus return. We can get your campus return. It was they put it on there.
I didn't.
Let's see.
Just enough to get you to come in.
Well, let's see. Wow. Does he have an attorney? Robert Klingler. Sure he did. We didn't have anything here, right?
Yeah. Let me check. I'm gonna run down to the back real quick and check in on the case.
Oh, okay, so this person had been in the Will Rainy Correctional Institution until the 5th. So then he was released and they brought him here for his return. So, Ask Mr. Klingler if, he wants to stay on the case, but we'll have an answer for you by the time you come back.
All right.
But my thought is to ask Mr. Klingler if, you can, move it to Monday next week because he's on.
Yeah. And looking at it Monday, we should do that.
Yeah, we don't have Monday with attorney, so,
All right, I'm gonna run down to the back, real quick, check it out.
all right, thank you. Yeah, that would work, this how, I knew it was a Thursday. Yeah.
I'll make a push for you. I appreciate it.
Oh, okay.
Thank you, Ron. Have a good day.
And you too.
Bye, Miss Howard.
Please, my hope.
Have a good day. I don't know how. Because I know the meeting, he said, there are 20 cases today, but we have no cases tomorrow. And tomorrow is the Sunday. I don't know if was Howard's thinking of that.
Well, what happened was, all these days are already set, then we set the Zoom. He said, he talked about the Zoom act, these days are already set.
No, I understand that, I'm just wondering why there was no cases set. That's my thing, like, I will get 20 cases on the day, done tomorrow.
Because there was a time that we were still making the day for you to do writing.
Oh.
And so if there was enough knowing there, it was like, we have to see it in.
Gotcha. Well, we can still use it as a writing period, that's good. It's not like we don't have stuff, we still have to do it. So it's still. Good. All right, well, let me give you some time to finish up those.
I know, right?
I can just give this Howard time to tell him. Do the administrative stuff she has to do, so it works out good.
I'm grateful.
So Ms. Howard, did you say that Mr. Winky and Mr. Tierney were outside?
Mr. Winky came in and said he was talking to Mr. Tierney about, his key, he must be over there doing this, because he's not in the hall.
Okay. Is that what it's like on and we can finish our topic?
Yeah,
So now we're just in a holding pattern.
let me tell Mr. Winky, let me see Mr. Tierney.
Can you go out there and tell them, Ray?
Yeah, I thought you were here.
Made a request for it, which we requested it almost a month ago, but haven't gotten it yet. Yeah, there are. It's hard to prove, it's not hard to prove, you have to track that. Yeah. It was 6, 2005, 95, 95, 34. Need that Okay. On the third report, given that, but research this record. Yeah. Yeah, if you had no like one chart from 80, 90, 86, whatever it was, that'd be different, but you got a lot in the middle.
I'm sorry.
You ready?
Yes.
All right. Let's discuss that one just one moment. All right, this is the matter of City of Ohio versus Michael Evans, case number B2103443. Ms. Elizabeth Selby is present for Mr. Evans and Mr. McCroswell from the City of Ohio. Ms. Selby, is Mr. Evans here?
He is not, Your Honor.
With his presence?
Yes, Your Honor.
All right. How do you want to move this forward? It looks like last time you did receive body cam evidence, and you're still waiting on one evidence?
Yes, we are still waiting on the 911. Usually it's the other way around as far as
Yes.
how the discovery comes in. We may, so I'm hoping to get the 911, but I think we may be nearing a resolution.
Okay. All right, well, would the 30-day continuance help in getting the time to get the 911 call and your negotiations?
Yes, Your Honor.
All right, let's continue 30 days.
The 13th of January. It's a little past 30 days.
Nice.
I've got room A that morning, so
We do, January 4th.
January 4th, does that work?
yes.
All right, January
And,
9 a.m. You wait time?
I waive time, Your Honor.
All right, thank you very much, and we'll see you January.
Okay, thank you.
Thank you, Your Honor.
All right, thank you.
And the carpet looks very nice.
Thank you. Mr. Tyrion, hi.
Hello, Your Honor.
Have you and Mr. Winky had our time, that's totally ready?
I believe
so. We have your
All right.
And, if you got, I made a decision. This,
Oh, yeah, that's fine.
And then, yeah, there's an affidavit that's for the inventory. Judge, I had one more item I had to fill out, which is an affidavit for the mandatory.
All right, when we're done, you can.
Yes, so I just didn't have that. I don't know if, do you have an affidavit of indigency over there? Okay, thank you. I'll be right back.
Okay.
Yes.
We can answer that, let the judge know.
You ready?
Can we approach them?
Absolutely. All right, let me tell you first of all, council, that this, here is, I'm testing out some new options to public transparency, and so we are streaming live right now, on YouTube. This is on the second day of it. I'm not doing it every day, we're just testing it right now. Some days we'll do it, some days, a lot of days we won't. We'll see how it works, so I just want to let you know, even though this is the first day that it's been on, and it's going to start. When we go by IT, it's better to keep that way. Rather than having people looking at it.
I don't want to see myself.
Me,
I have a
so.
face grade.
So I just want to.
The question would be, I was told to put it on the there is a violation.
So that, yeah, we're moving this.
There's two different versions of that, three. Okay, yeah, I'm just saying.
Yeah.
Just wanted you to be aware.
It's like this stuff before, it's going to be.
Thank you.
So, getting this up.
I have not heard the end of that.
Yes.
Your Honor, may I approach with the forms?
Yes, sir.
The remainder will be the one, I didn't know how to work it, because I signed it, so to you.
Okay, yeah. Thank you. You did great. Thank you. Ms. Howard, can you print me out Mr. Purdue's complaint? Okay. You got it? Yes, ma'am. All right. All right, this is a matter of State of Ohio versus Ivan Purdue, case number B 2101991. Mr. Purdue is present in the courtroom with his attorney, Mr. Stephen Winkie. Mr. Mark Tierney for the State of Ohio is also present. This matter was set on the previous day for today for a plea. It's my understanding the parties have been diligently working even up to this morning, and I've been handed plea forms. And your client wishes to enter a guilty plea today?
Yes, Judge, we've negotiated a plea whereby counts 2 through 8 will be dismissed. And on count 1, the body of the indictment will be amended to exclude the priors.
All right, and is that accurate, Mr. Tierney?
Yes, Your Honor.
All right, Mr. Purdue, is that your understanding of everything?
Yes.
All right. Are you the Ivan Purdue named in this indictment?
Yes.
How old are you, Mr. Purdue? I can't hear you.
39.
39? All right, you guys are just a little while. All right, how far do you go to school? All right, so you do have your VD. All right, I think you might be able to turn that mic on.
It was on.
Is it on?
It was.
Testing.
All right, thank you.
It's just a little bit low.
All right, so you did obtain your VD, correct?
Yes,
All right. Are you able to read and write the English language well?
yes.
All right. Sir, have you ever served in the military?
No, ma'am.
Are you a U.S. citizen?
Yes.
All right. Mr. Perdue, I have in my hands two forms, plea forms. One is a waiver of trial by jury. It's a single-page document. At the bottom of the page, there are signatures. I recognize Mr. Winky's signature here and his bar number. Is this your signature here, sir?
Yes.
Did you sign this form after consulting with your lawyer?
Yes.
When you sign this form, you are indicating that you understand you have a constitutional right to have a trial. But when you sign it, you're saying, I understand that, but I'm giving up or waiving that right. Is that your understanding of what you were doing when you signed this form?
Yes.
Do you have any questions about the waiver of trial, speedy trial, a waiver of trial by jury?
No, ma'am.
All right, I'm sorry, I kind of confused you there. All right, do you have any questions about this waiver of trial by jury form?
No.
I also have an entry withdrawing plea of not guilty and entry of plea of guilty. It's a 3-page document, and on the 3rd page, there are signatures. I recognize Mr. Tierney, the prosecutor's signature here, your attorney's signature here, and his bar number. Is this your signature up here, sir, where it says signature of defendant?
Yes.
All right. Mr. Tierney, would you please put on the record the party's intention concerning this matter?
Yes, Your Honor, the defendant is going to plead guilty to count 1, as Mr. Wayne indicated earlier. We're requesting dismissal of the balance of the indictment, and then there's been no, we had discussions relative to an agreed plea, but that is not part of the plea arrangement. We intend to argue the various positions of each side relative to sentencing to the court.
All right. Thank you. Is that accurate, Mr. Winky?
Yes, Judge, the one item would be the amendment of the first count to exclude the priors, which I mentioned before.
All right. Mr. Perdue, is that your understanding?
Yes.
All right. Are you under the influence of any medications, alcohol, or drugs today? Sir, do you now, have you ever suffered with or even been diagnosed with any type of mental health illness or disease? Are you presently under any type of probation or community control supervision in this or any other state?
No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into these pleas of guilty today, this plea of guilty today, other than the dismissal of counts 2 through 8 and the removal of prior convictions in count 1?
No.
All right. Are you making this plea of your own free will?
Yes.
Now, the state has indicated, and your attorney has agreed, that you would be entering a plea to count 1 as amended and reduced. Well, is it amended? Is it reduced or just amended?
Not reduced, Your Honor.
It's amended to delete or dismiss the prior convictions, but it's still F3, felony in the 3rd degree, aggravated trafficking. Is that your understanding? Is that what you're talking to your lawyer about before this proceeding today?
Yes.
Sir, did you have an opportunity to either read or discuss this plea form with your lawyer before signing it?
Yes.
All right. Do you understand what it says?
Yes, yes.
All right. You have any questions about it?
No, not at this moment.
All right. Do you feel that you've had enough time to consult with Mr. Winky about your case before this proceeding today?
Yes.
Has he answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and discuss the evidence that the state has against you with your lawyer?
Yes.
All right. Mr. Tierney, would you put on the record whether or not the state has provided all discovery to your knowledge, including any Brady material, if any?
I believe we have.
All right, Mr. Winky, do you acknowledge receipt of same?
Yes, Judge.
All right. Mr. Perdue, are you satisfied with your attorney, Mr. Winky?
Yes.
Sir, do you understand the charge against you, aggravated trafficking, felony in the 3rd degree?
Yes.
You understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment?
Yes.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, sir, this being a felony of the 3rd degree, do you understand that you are facing up to 36 months in prison? So 9 months up to 36 months in prison, and a fine of up to $10,000. A maximum fine of up to $10,000. Do you understand that that's a penalty?
Okay. He had a question, Judge, not just, he was concerned, he's also eligible for probation under this
I'm
circumstance.
gonna talk about that.
That's right, that's what he's confused on, okay? The issue right now is she could give you up to 36 months if she chose to do so, Judge.
Do you understand that?
Yes.
All right. Do you understand that the maximum fine, in this matter is up to $10,000?
Yes.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes.
Are you on post-release control?
No.
Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, that in addition to being punished with a new felony offense, the sentencing court could add an additional 1 year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes.
All right. Now, since this is a felony of the 3rd degree, do you understand that community control is a possibility?
Yes.
Do you understand that I could place you on community control probation for up to 5 years instead of sending you to prison?
Yes.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes.
Do you understand that if I place you on a community control sentence and you violate the conditions of community control, you would be brought back before me for a more restrictive sanction, which could include a number of things, the maximum being up to 36 months in prison. Also, if I impose court costs and you fail to pay the court costs, do you understand that I could order you to do community service instead of paying court costs?
Yes.
Do you have any questions at this time, Mr. Perdue?
Right now, the only question I have is, I've done, like I'm gonna,
The card you got for your carpentry? Okay. He had one question about the return of some of his property, Your Honor. It's not necessarily relevant to this, but he had that question. I'd informed him that after he's sentenced, it's likely he could have that returned. I hadn't had that conversation yet with Mr. Tierney. Not money that was taken by way of forfeiture, but ID cards, and I think he had a card from his carpentry classes.
my certification of my carpentry and.
Your service?
Certification of my carpentry, level 1 carpentry and stuff. My documents, proving my certifications.
I understand. And that's something certainly that your attorney can talk to Mr. Tierney.
It is. It's been my experience after sentencing, typically those types of items would be returned. Right now, they're relevant to the charge.
Yes. Okay. You understand that? All right. Do you have any questions about what I explained to you so far about the penalties and the possibility of community control and the fine? Do you have any questions about that? Okay. Sir, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a right to a trial either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you.
Yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt as to each element for each crime for which you're charged? Do you understand that you cannot be forced to testify against yourself at trial?
Yes.
All right. Do you understand each of these rights as I've explained them?
Yes.
Do you have any questions about your constitutional rights? Sir, do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
Yes.
Knowing everything the court has discussed with you today, Mr. Perdue, do you still wish to enter a guilty plea to count 1 as amended, aggravated trafficking of drugs, felony of third degree? Is there anything further from counsel before I accept the plea?
No, Judge.
All right, name your statement of facts.
I had something to say before the facts, though. That
Okay, yes, sir.
It's relative to the plea. Mr. Lincoln and I have discussed this at length, but I don't want the defendant to be under any misunderstanding. I know the defendant's going to ask the court to place him on probation. You're going to be asking to place the defendant in prison towards the top end of the sentence. An open plea, so to speak, but I just want to place that on record. And Steve and I have discussed this, Mr. Lincoln and I have discussed this many times. But that's not, I just want to be clear about what my intentions are before the defendant goes this way. So
All right, thank you very much for making that clear.
because we did, relative to the plea agreement, we made the amendment relative to count 1. It's not that I'm not going to argue that later on.
All right.
Thank you.
So do you understand, Mr. Perdue, that the prosecutor is saying that, yes, they made an amendment to dismiss the prior convictions as alleged in count 1. But it's still a felony of third degree. But they didn't want you to be confused or misled that they're still going to ask you to be sent to prison at sentencing.
Yes, yes.
All right. And your attorney is still going to ask that you not be sent to prison at sentencing. Do you understand?
Yes.
And ultimately, it's up to the court.
Yes.
All right.
Thank you.
Thank you.
As count 1, item to do on about the 12th day of April, year 2021 in Hamilton County, the state of Ohio, knowingly prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed Schedule 2 controlled substance, 2-wet methamphetamine when the said defendant knew or had reasonable cause to believe that the substance was intended for sale or resale by the defendant or another person in an amount that equal or exceeded the bulk amount, but was less than 5 times the bulk amount. And this would be in violation of section 2925.03A2 of the Ohio Revised Code. The narcotics were discovered in the defendant's vehicle prepared for distribution, and they tested positive as being methamphetamine by the Hamilton County Coroner's Lab. That's all I have on the facts.
All right. Thank you very much. Anything on the facts, Mr. Mickey?
Nothing on the facts. I would just put on the record, I've had numerous discussions with Mr. Perdue. Originally, there was a motion to suppress challenging the traffic stop. We withdrew that after looking at all the specific facts, and I just wanted to put that on the record. That's all.
All right. Thank you very much. Yes, I do have the entry withdrawing a motion to suppress. You knew about that, right, Mr. Perdue?
Yes.
Because I went over that with you at the time. Okay. All right. Mr. Perdue, what is your plea? Well, first of all, you heard the prosecutor say you did, correct?
Yes.
The drugs being in the car.
Yes.
All right. Is it true?
Yes.
All right. What is your plea to count 1 as amended? Aggravated trafficking in drugs, a felony of the third degree. Let the record reflect that Mr. Ivan Perdue was present in court with his attorney, Mr. Stephen Winky, and that Ivan Perdue was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ivan Perdue understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ivan Perdue guilty as to count 1, aggravated trafficking in drugs, a felony of the third degree, in violation of Revised Code 2925.03, subsections A2. Counts 2, 3, 4, 5, 6, 7, and 8 are dismissed at the state's request. Additionally, the prior convictions as listed in count 1 are also dismissed at the state's request. Is there any reason why sentence should not be entered today? Mr. Winky?
Judge, we would ask for a pre-sentence report.
All right, I will, go ahead and order a pre-sentence investigation report and set this matter for sentencing. We can go, 30, a little bit over 30 days if we can't get it in that first week.
Can we do, January 13th,
Yes.
January 13th at 9?
Is that all right?
Yes.
All right, Mr. Tierney, is that all right?
Yes, Your Honor.
All right, January 13th, 2022, 9 a.m. And Mr. Winky, I know you've done it before, so, but I just remind you, I really like the sentencing memorandums. It helps me understand more about who Mr. Perdue is outside of the probation investigation report. All right, and so I will keep the affidavit of indigency, I know he's filed that, I'll keep that for the day of sentencing. We'll just keep that at that time. Is there anything else, counsel?
No, Judge.
All right, Mr. Perdue, you must cooperate fully with the investigation. So probation is going to interview you, and then they're going to give you a report. All right, I'm going to ask you to cooperate fully with them, answer all their questions truthfully, no matter how painful it is to say it. But just answer truthfully. I'll get a report on the day of sentencing. Your attorney, the prosecutor will review it as well. I'll let them see it, and then we'll go forward. Okay? All right, and we'll do the same on. We'll see you then.
Thank you. Thank you. The form? Yes. You've been busy today, haven't you? I didn't know whichever cut there is. 53703 9373. Yeah, that's a good one. It's gonna be real easy. Thank you.
There's the file, there's no way to bring on the bill.
Yeah, I will.
Thank you.
Yes, thank you. I appreciate it.
Oh, you're welcome.
Straight your eyes, okay. So if you just,
That was always the thing about this room, you get blinded by the light. There's so much light coming in.
yeah, the whole thing. That's right. No, we can turn it down. It's no problem. We're done. Yes, it's done. CBA.
So this was the last week of jury trial, right?
Yes, sir. So if you didn't have a jury trial this week, you don't have a jury trial.
And we start
First week, January.
That's always the best time of year. This is right now. For work. Thank you. Appreciate it. Thanks for your patience. Thank you.
Have a good day.
Thank you.
You too.
Ms. Hopkins, you gotta turn this on. That's like.
Waiver.
Yeah. So really wasn't in here today.
He was.
Yes. so nice. And it does.